Now, as to the mechanics of the lawsuit, first you have to think, do you really want to sue? Again, I'm going to speak as if you are the plaintiff. You think your song has been copied. What should you do about it? What I first do when I have clients approach me is kind of sit them down and tell them a bunch of things. First, to get the negative out of the way, that it's a federal matter, it's a big deal, and you better not think you're going to get through it quickly. Whatever you've seen of a television series and courtroom happenings on television, forget that. It can be fairly fictional. If you lose, you're the plaintiff, and if the court was convinced your case was frivolous, you could be compelled to pay all the court costs, all the other side's legal expenses. That's easily to $1 million. Now, let's just say you know that and you're going to go through with it. You have that lawyer who's really good, and the lawyer's hired an expert witness who's really good. The expert witness writes a report. It gets filed. The other side counters. They get an expert witness. Sometimes they'll get 2 or 3. That could be to scare you or intimidate you, but that's what they do. There are the federal rules of civil procedure, and a lot of the rules apply to the behavior and testimony and the mechanics of the expert witness, how they carry on, how they act. And there are rules for the judge, there's rules for the lawyers. Often things can go wrong in that process. They can go right and they can go wrong. As I've mentioned, there's discovery. You want to discover all the facts. You want to use what you think works that benefits your side and your cause. Then there'll be a deposition. So your expert wrote a report. It becomes part of evidence, and it's going to be an exhibit or several exhibits in a potential trial. But it's all under oath. Once a trial takes place, a lot of it's a reenactment of what happened 1 or 2 or 3 years earlier. If you said they're very similar 2 years ago and now you're saying they're extremely similar, well, the other side would say, well, which is it? How come you've changed your testimony? Just by changing one word. So a lot of it is very nitpicking into great detail. You have to make sure you're consistent. Eventually, you do work it out. You have depositions of an expert on his or her credentials, his or her report, all the findings, what procedures and processes they used. If you find they're not that good, you can get them excluded. And if you exclude an expert witness, that means they have to go through the whole process again. That won't look good. That's going to cost a lot. There are often times like that where you start to find, we can settle this. Let's just settle this. So most of the times things do settle. But should they go to trial? It's just very serious. You have to repeat everything you had said. Don't change your findings. Don't say, now that I've thought about it, I think this way. Just to let you know, there's a lot that takes place in the trial. There's discovery, depositions, a lot of cross-examination. You look at how good the evidence is, how believable the witnesses are. And that's another thing, is that a judge gets to assess someone. Like, are you a believable person? What's your background like? And your background is pertinent. If you had DUIs, that you have to tell the court. If you have any criminal offenses, civil or criminal, it's all public record. It's a big deal, but if someone copied your music, that's a big deal. The minimum offense, the minimum fine is $750 per infringement. The maximum is $150,000 per infringement. So it's very easy. The trials can run up into the millions of dollars as a reward. The Marvin Gaye Blurred Lines case, the first award was $7.3 million. So I hope that gave you an idea of what takes place, the mechanics of a copyright infringement lawsuit.